Judge, define originalism for me. Do you know what purposivism is? Tell me what Article 5 of the Constitution does.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Neither is Article 2.
Okay.
Ladies and gentlemen, welcome back to America First, the channel where we stand up for the Constitution, expose the radical agenda of the left, and remind every American what this country was built on: freedom, accountability, and the rule of law. Before we get started, make sure you smash that like button, hit subscribe, and ring that bell, because if we don't keep our leaders in check, no one will. Now, folks, what you're about to hear should outrage every American, Democrat or Republican. This isn't about party politics. This is about something much bigger. This is about the integrity of the federal judiciary and how it's being eroded by unqualified, partisan, and frankly ignorant nominees being pushed by the Biden administration. In a recent Senate Judiciary Committee hearing, Senator John Kennedy of Louisiana, one of the last honest men in Washington, grilled 3 of Biden's judicial nominees, Judge Bjelkengren, Mr. Brookman, and Ms. Merchant. What should have been a basic vetting of their legal knowledge turned into a civics class disaster.
Thank you, Mr. Chairman, and congratulations to all of you. Judge, on the far end, tell me what Article 5 of the Constitution does.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Neither is Article 2.
Okay. Do you know what purposivism is?
In my 12 years as an Assistant Attorney General and my 9 years serving as a judge, I was not faced with that precise question. We are the highest trial court in Washington State, so I'm frequently faced with issues that I'm not familiar with, and I thoroughly review the law, research, and apply the law to the facts presented to me.
Well, you're going to be faced with it if you're confirmed. I can assure you of that. I can't really see from this angle, I apologize. Mr. Brookman, define originalism for me.
Thank you, Senator, for that question. My understanding of originalism...
I'm going to turn your microphone on.
Thank you, Senator, for that question. My understanding of originalism is the notion that the Constitution has an enduring and a fixed nature, an enduring quality and a fixed nature to it.
What does that mean?
It means that the words matter, and that the words that the framers used to draft the Constitution matter, and that it has a fixed quality to it and has an enduring nature.
Well, how do you determine the fixed quality? Who determines what the words mean? From whose perspective?
Senator, in my time as a magistrate judge, I've not dealt with issues of constitutional interpretation, but my understanding is that you would begin with the language of the Constitution itself.
Yeah, okay, I agree with that. All right, anybody want to add? Counselor, Ms. Merchant? I mean, here's what I'm getting at. When you say originalism, the words mean what they mean. From whose perspective?
Thank you for the question, Senator. Similar to my colleagues, I would look to the text in terms of originalism. When you're asking, to the extent that you're asking what I would look to, if so fortunate to be confirmed as a judge, I would look to the precedent, first of the text.
Yes, ma'am, but I'm trying to get you to define originalism for me. What's your understanding of it?
Yes, thank you, Senator. To clarify, my understanding of originalism is similar to that of my colleagues. And in looking at the text and the meaning that was intended in that text, that is the spirit of...
Intended by whom?
By the original writers of that text.
So to you, originalism, you try to interpret what the writers, the authors meant?
In an analysis, a constitutional analysis, it would be the originalism, the text, and the intent of those that drafted the Constitution.
I don't think that's accurate. Does anybody disagree with that? When the Supreme Court says it's following an originalist approach, and in a number of cases, all particularly dealing with the Second Amendment, the U.S. Supreme Court has said, on this one, we're all originalists. I think it was Judge Sotomayor who said that, Justice Sotomayor. And on many areas, she's more of a proposivist, but on that she was an originalist. She didn't say we're looking for the meaning that the drafters intended, was she? Anybody want to add to that?
Senator, I'm happy to add to that. My understanding is that
That's okay. Let me just ask one more. I'm about to run out of time. Judge on the far end, can you tell me what the independent state legislature theory is? I'm just asking you, not your opinion of what is it? It's before the Supreme Court now.
In my 12 years as a Washington State Assistant Attorney General, and
Right.
that particular doctrine was not presented to me.
I'm out of time. Thanks, Mr. Chairman.
Let's talk about the moment that set the internet on fire. Senator Kennedy turned to Judge Bjelkengren, a nominee for the U.S. District Court for the Eastern District of Washington, and calmly asked, "Judge, can you tell me what Article 5 of the Constitution does?" Her answer? Article 5 is not coming to mind at the moment. Then he tried again. How about Article 2? Her response, neither is Article 2. That's right. A sitting judge, nominated for a lifetime appointment to the federal bench, couldn't recall the articles that explain how we amend the Constitution or what powers the executive branch holds. For the record, Article 2 lays out the powers and duties of the President of the United States. Article 5 describes how amendments to the Constitution are proposed and ratified. These are not obscure legal doctrines. This is the foundation of our republic, and she didn't know it. Then came the question about purposivism, a legal philosophy that says judges should interpret statutes based on their intended purpose, not just their text. You don't need to agree with that philosophy, but a federal judge ought to at least know what it means. Judge Bjelkengren didn't. She said she had never been faced with that question. Senator Kennedy didn't stop there. He turned to the next nominee, Mr. Brookman, and asked him to define originalism, the principle that the Constitution should be interpreted according to its original public meaning. Brookman gave a vague, half-hearted definition, saying originalism means the Constitution has a fixed and enduring nature. When Kennedy asked who determines what the words of the Constitution mean, Brookman said, "You start with the language." That's not enough. What about the context? Who defines the meaning? What's the methodology? He couldn't answer. Ms. Merchant, the third nominee, offered the same recycled talking points. She claimed originalism meant looking at the text and the intent of the original writers. Kennedy pushed her. Intent from whose perspective? No clear answer. When you're a federal judge, you don't get to shrug your shoulders at fundamental constitutional interpretation. You have to know, not guess, how to apply originalism, textualism, and the other pillars of legal theory. This is what separates judges from activists. I know what some people will say. Come on, give them a break. They were nervous. It's just a hearing. No, this isn't a job interview at your local law firm. This is the federal bench. These are the men and women who will decide your Second Amendment rights, your religious freedoms, your children's education, your medical choices, and more. They are interpreting the most powerful legal document in history, and they don't even know what's in it. Senator Kennedy then asked Judge Bjelkengren about the independent state legislature theory, a significant constitutional doctrine currently before the U.S. Supreme Court, a theory that could reshape how federal elections are governed. And again, she said she had no knowledge of it. Let's connect the dots. These aren't just random week nominees. They are intentional picks by the Biden administration. They represent a radical transformation of our judiciary, one where knowledge is optional and ideology is mandatory. They're stacking the courts with people who are politically compliant, not constitutionally competent. People who will defer to the administrative state, to social justice trends, to whatever the woke agenda demands, instead of the rule of law. And once these judges are confirmed, they'll be there for life. This isn't just a bad episode of Are You Smarter Than a Fifth Grader? This is a national emergency. Because if the Constitution doesn't mean anything to the judges who swear to uphold it, then it doesn't mean anything at all. So what can we do? Demand better. Contact your senators and tell them no to rubber stamping unqualified judges. Stay informed. Keep watching America First, because mainstream media sure won't tell you the truth. And most importantly, fight back. Not with violence, but with knowledge, with courage, and with our voices. If this video lit a fire in you, smash that like button, subscribe to the channel, and share this with every patriot you know. Because the fight for our judiciary is the fight for our future. This is America First, and we're not backing down.